Rob, what's up, my brother?
Oh, good. Love your studio, man.
Thanks, man. So Rob Drolet is a IP attorney extraordinaire. Many years of experience, as you can tell by the gray hairs. Great looking individual and badass lawyer all around, man. So I'll let you give your intro to a little bit about yourself and maybe about the current company that you're working with.
Sure, sure. So, first career, nuclear engineer with the Navy,
Oh, had to
retired
start with that
from the
one.
Navy, and then did some professional engineering work. Dabbled around with helping out with patents. Uh, then I really became brain dead and went to law school, became a patent attorney, and solely with the purpose of going ahead and utilizing my technical engineering background, professional engineering skills to parlay into something else. What I found along the way is I really found I love being a lawyer. There are a few things that you can do on this planet where you can help people, really help people.
Mhm.
And make me as a patent attorney and an IP lawyer, as Rodrigo said, I help people with their dreams. I help people. I like to think of myself as help expedite their dreams, man. Because we spoke earlier about economic times. There's always blips in our history where we have economic hurdles we have to overcome. But we always, as humans, have dreams, right? If you don't have dreams, you don't have aspirations, you don't see the light at the end of the tunnel, then life becomes a bad place to be.
Yeah.
I'm blessed and grateful, and I'm in a profession, and I'm in a place where I work with people like Rodrigo, and we help bring their dreams alive, man. Give them context. What I do specifically as a patent attorney is I actually create property. I help people create property, create just like a piece of real estate. People with a blank sheet of paper in front of them with an idea, they can start putting things to paper and express themselves. And guess what? With time and effort, you create something. You create property. It's real, right? You can sell it. You can license it. You can pass it on. You can improve on it. So it's a cool thing to be involved with. So yeah, so that's kind of what I do today. I help people that like Rodrigo works with and help protect their intellectual property.
Nice, nice. And we've been working together. I don't know how many years now, but
Yeah, a few
what?
years.
Yeah, how many patents do you think we've done together, man?
15, 20 around that time frame, around that areas. Yeah. Unfortunately, not every idea, and with business people, it's kind of cool. We've also been involved with letting people know what they need to hear, not what they want to hear. Sometimes
Right.
after your research and stuff, we tell them point blank, hey, look, you're gonna have these hurdles. But sometimes you need people to tell you exactly the landscape, right? Exactly a good roadmap, right? So along with those people that we've been successful in getting them an actual property right, intellectual property right, I think we've been successful too in making sure business people don't go down the wrong road, right?
Mm-hmm.
So I think we can also count our successes there. That's part of our deal, right? We want to help our clients go down the right path.
Okay, here's a good one, man. I mean, just in general, what's the best advice you can give to a new entrepreneur or inventor that has an idea? What's the best advice you can give them?
With respect to trying to bring it to life, get yourself protected. A lot of people use NDAs, non-disclosure agreements. They're only as good as the person that's signing it. It doesn't
Mhm.
help you with chasing them down in court. Uh, I think the best protection you can get is actually getting some sort of protection on your idea, whether it be a design patent or utility patent, or getting a provisional of its utility.
Here's another good one, man, that I often ask myself, right? When it comes to getting a patent, when is it a good idea or appropriate to skip a provisional patent and go right to a utility patent? Because there is a savings, right, by going directly to that? Is there not?
Well, not really. There's a savings by doing the provisional in the sense that if there's
By
not
not?
if there's no traction, if there's no commercialization, or after you've done your due diligence after trying to get it going, you don't see there's a market, then you've saved yourself the additional costs for utility. Now,
True.
when would you go for utility? Right off the bat without going to provisional. One, if it's a sure thing you want to bring this to market now, and it's important that you have a patent that you want to get it now, right?
Mhm.
If the person's older, right? You can get prioritized examination. You can get different consideration if it's solving some of the things that the USPTO, the patent office, deems necessary for society. COVID related things that just
Mhm.
recently they got
Yeah.
added to the list. Cancer stuff.
You mentioned it a little bit, man, but like, what are the options on expediting? I mean, you talked a little bit about like if it's a COVID thing. I know that they had an expedited process put in place. Can you tell us a little bit about like what are the options and what are the fees associated?
So when we start talking about fees, well, first before we get to the specialized application types, there's different fee categories depending upon whether you're normal, a large company, a
Mm-hmm.
small entity, or micro entity.
Mm-hmm.
Micro entity is the lowest cost, and that's if you're a single inventor, you have a median income of your last IRS income taxes that's less than 150% of the median, which I think right now it's about 189,000. If it's less than that, you qualify for that. And if your name is on less than 4 patents as an inventor or co-inventor, you qualify. I said 4, but it might be 4 or 6. I think it's 4. But that's
Mm-hmm.
micro entity. That applies to most of the fees that are involved in patent prosecution. You actually, managing the patent to becoming the application becoming an actual patent. Now,
Mm-hmm.
within that, you also have some other types of prioritized examinations. For instance, if you have the extra money and you're a micro entity, you qualify for micro entity, you can ask for a prioritized track 1 examination, which currently right now the patent office will say that they'll have a decision for you within 12 months. My
Mm-hmm.
experience, that's true. They will have a decision for you within 12 months, and it's pretty good process for a micro entity. And for micro entity fee, it's a little over $1,000 extra. That's the patent office. There's a little bit more for the actual legal fees involved in that. Just a few $100s more. That gets you answering your patent. The other categories you mentioned, if you're inventor of age over 65 years old, if the subject matter is something that's solving something that the U.S. Patent Office is deemed vital, like most recently COVID, solutions, you get prioritized examination as well.
It's awesome, man. That's really cool that they do that. I mean, because there's a lot of great minds out there that have gone through, their greater working years and have all these ideas on their minds. I mean, let's say when you get towards retiring, you get a lot of time to think about things as well. And, you have, all we have is the time we have on this planet, right? So you want to, if it's your dream to bring an idea to life, at least here what they're doing is they're trying to help you do it quicker so that you can, you don't have to waste as much time waiting.
Yeah, well, I'll tell you what, man. Most people think that you're supposed to make your cash when you're young. The thing about intellectual property, especially about solving things that are out there, I found the technicians or engineers or artists or people that are out there in a profession with years of experience, they gain an insight as to what works, right? What things may work, or what definitely doesn't work.
Right.
And sometimes those people come up with these ideas after they've been involved in their field for a while.
For example, I have another client. His name is Heinz. I'll have him come on the show sometime. He's a character, man, hardworking guy, has a lot of really great ideas, and he paints for a living. Construction. He's done other things, but lastly, the last I think 5-10 years, he had a painting company, and he since came up with a new invention for a paint can, and also with something I can't get into the details of it, but a new paint can that has a bunch of cool features to it. Also, paint brushes that have innovative ways of painting, so that you can, you know, just creates like a flexible product that can be used for multiple uses. And
Love it.
this guy keeps on coming after one idea after another, after another, after another. So, you know, he just needs to get one of those to take off so that he can, you know, really fund all his other ideas and just enjoy bringing ideas to life, you know?
I think it's cool. I think it's cool. You know, contributing to society, man. You know, that's what these people are doing.
Yeah.
It's a beautiful thing.
So, all right. So I'm going to give you one hard question. Are you ready?
Sure.
All right. And this is my opinion, that some IP attorneys, in situations where their clients obviously can't get a utility patent, they just try to sell them a design patent. I don't know if you ever heard this, but I've seen it a lot. I've seen it a lot with people at you know, companies, all the big invention companies. I don't want to name any specific one. I don't want to get sued unnecessarily, but all the major companies, you know, they're basically like referral services almost more than anything, and
Yeah.
they're connecting the attorneys with the clients, and a lot of times they come to me, but really what they have is like nothing, next to nothing. I mean, what does a design patent, you know, really protect? I mean, you know what I'm saying? If I can just change it, you know what I'm saying? Because the people
Yeah.
are trying to get a utility patent and they don't really know better in a lot of cases, man. And, I mean, you know what I'm saying? You have to understand, guys, that there are millions of patents that are applied for, right? I mean, how many patents a year? Do you know off the top of your head, man?
Well, I mean, you've got a whole bunch of applications. They're increasing with time, but right now you're, you know, over, you know, the patent count as far as patent number of patents, it just 11 million, you know, 11 million and change, you know,
But that's
that's
what
kind
exists
of
now.
that's what the current counter is right now. So
Mhm.
there's a lot of patents out there. But
Yeah,
to answer your question about the utility design, those are two different things.
absolutely,
So
absolutely.
I've never run across well, again, I don't run too many. I don't interact with other patent attorneys to talk about this issue per se, because they're two different things. If you would ever look at a design patent and contrast it to a utility patent, you'd understand there's such a distinct
Yeah,
difference. A
yeah.
design patent just protects the way something looks. That's
Grab me
it.
one. Grab me one
You
of those.
know,
Left.
if you look at an application for a design patent, it's
Mhm.
got a one paragraph, and the one paragraph saying, I I'm protecting
Close
my
enough. So,
idea as it exists in these drawings. You've got some in your studio design
yeah,
patents, right? And it's one paragraph. The paragraph says, I'm protecting everything as they show in the drawings. And you're protecting how it looks, right? So if
yeah,
something
yeah.
looks different than what it is, what you're doing, you're not protecting the functionality. Matter of fact, that's what utility means. You're protecting something the way it works, not the way it
Yeah.
looks, right? So, but yeah,
See,
design. I I've
I
never seen that. So
so look, man, invention mills are basically, they don't care. They don't care. You know, I mean, that's my opinion, right? But I find that if you call a company and they have 100 salespeople and 10 designers, that, you know, their focus is, that's their focus, right? Now, like a team like myself, we have 2, 3 salespeople to 14, 15 people, 14, 15 designers. So if you understand what I'm saying, right? So um, that's what their focus is. You know what I'm saying? Some it's more on just, they just want to go through as many as possible, and some are actually like more focused on the actual work. That's what we do as a product development company, which is different to an invention promotion company, right? It's a very distinct difference where we focus on developing the idea. They're more talking about, you know, we're gonna make you $1 million by helping you license your idea. We're gonna show it to a bunch of people and promote your invention. And if we sell it, then we get a percentage. And if we don't sell it, then we don't sell it. And you know, it's a different offering, and seems like the easy way for a lot of people. But I mean, the numbers for licensing aren't the best, from my knowledge.
Yeah, no, just because you have a patent doesn't mean it's commercialable. It doesn't mean it's going to sell. And that's part of the process is, engaging with the entrepreneurs, just trying to make sure that they have a path going forward. A patent, you can get a patent that really doesn't have much value. It's very narrow. When I say narrow, it's very specific, right?
Hmm.
It's only you're
Hmm.
only claiming a certain set of things or elements, and it could be that you're just so very narrow that it doesn't really have much commerciality. So,
Hmm.
but getting back to your thing with design and utility, two different things. I understand the people out there that do want to just get a patent, and they want to get the person to have a patent so he feels the ego and the oh, I got a patent. But the design patent has no protection in any way, shape, or form of utility, right?
Hmm.
So,
Hmm.
so yeah, utility is the way it works, and it's if you said if you contrast a design patent to a utility patent, two different things. Utility patent describes in your what it is of how something works or what something
Hmm.
is.
Yep.
So, yeah,
So when is a good time then to use a design patent?
if it's a unique design, if it's something that is coupled with, let's say it's coupled with your a utility. Let's say it's a for I'll give a good example, cell phones. Cell phones have a whole lot of patents in them, and the majority of them are utility, right? How they work,
Hmm.
how the things inside are constructed to make something work.
Hmm.
Uh, but they also have the design features, the beveled edges, the round features, the aspect ratios of the width to length ratio, all
Hmm.
those things, the foldability of it, all those things can come along with the uh, utility patent and actually enhance the commerciality of that thing.
So it works well for like a big company, but does it also help a little guy?
It could. I guess it depends on the context. You have to tell me. I have to be specific, I guess, as far as the design of what. It could be, as long as it's not functional. The shape of something could be it has have a utility. It could be shaped a certain way for aerodynamics, for instance, or for drag, or for ease of use, or whatever. Um, and that's a different protection, right? That's utility.
Right.
But um, but a small person, a small idea could have a design patent attached with it. It'd be depending upon the context. We have to talk about a specific thing to be able to
Yeah.
kind of contextualize it.
But just from this I mean, I don't know, just from spitballing, it seems like it's not the optimal route in most cases.
Design patents have their place. Design patents don't have the breadth of protection utility does, because it's like I said, if you're looking at the design patent, all you're doing is protecting the way it looks. And you
Hmm.
look at design patent, the way it's published by the patent office, it's a series of drawings and
Hmm.
perspective, it'd be back view, top view, side view, and you
Yeah.
protect the way your thing looks.
So a lot of times, we'll have I'll get somebody that brings me a design patent, and they haven't even prototyped this thing yet. And a lot of times, to make the thing function, it's not going to look exactly like what the
Yeah,
design
no,
patent is.
yeah.
So it does not make sense. I think we agree here that it doesn't make sense to get a design patent before we have, um, you know, you know, thought it out, prototyped it, make it work the way it needs to work, and then you get a design patent. Is this correct?
Design patents, after it's ready to go, you already conceptualized how it's going to go to the market. Why? Because that's what you're protecting. If you try to get a design patent before you've actually gone through prototyping and how it's going to look and feel, you've lost money, and you just wasted money because you're not protecting the end product. That's what you want to protect, the end product of how it looks when it's all
Rob,
said and done. So
thank you
you got a
so
lot
much.
of work. You got a lot of work to do before you even get to the point where you're going, aha, here's where my design is going to be.
So most people don't. I mean, I don't know if you guys know, but he just saved you like $3,500 at least on doing design patents when it's not at the right, in the right time, right? Not if you do it at the right time, then you save a lot of money, right? If you have to do it twice, guess what? It costs you $7K to get a design patent instead of 3 or 4 or whatever it costs, right?
I believe any inventor or any person, any entrepreneur considering a design patent, just look on the USPTO website, the U.S. Patent Trademark Office website, and start looking at some design patents and understand what they protect. It's the way something looks. So if the way it's going to look when you're all said and done and it's on the shelf or when it's on online to be sold is not what you're protecting, you haven't achieved your objective of protecting your product, right? So it's not until you're there and you're just like, aha, here we go, right? Yeah, that's when you do it.
Rob, that's why I love speaking with you, man. You always have such great information to share, man, and definitely look forward to doing more work together. And this was a great opportunity to kind of introduce you to all the people that it's like an early introduction to you for all the people that I refer to you, and they can just click the video and watch. And that's my goal, is to be able to bring bring the character to the picture. You know what I'm saying?
Yeah.
And let people get their feel of who you are. And you're an amazing dude, smart, easy to talk to, very knowledgeable, and you bring a tremendous amount of value to all the clients that I've worked with, man. I thank you very much for always being there and answering the phone quickly and responding quickly. That's something that, that's kind of priceless. It's hard to put a price on that,
Thanks. Enjoy working with
you. Yeah, buddy. One last thing, man. What languages do you like to speak with your clients in? What languages do you provide service?
So I'm bilingual professionally in Spanish and English. In fact, I live half the year in Mexico, take care of international clients out of there as well. So
excellent.
Functionally Spanish and English. I can get by with some Portuguese, but not to the professional level that needs to be for this industry.
No, I appreciate sharing that, because I know that clients typically prefer to work with the legal team, specifically the legal team, man, but even in the design team as well. If they can't communicate well with us, the whole experience kind of becomes more difficult. You know what I'm saying? So being able to serve our clients in their native tongue, I think, gives them a better overall experience. And at the end of the day, like, the way I look at it, my product that is delivered to the client is not just the actual product, but it's also the whole experience that they have with us. And so I think it just gives it that extra special level of convenience. And thank you, Rob. I just appreciate that once again. Awesome, man. And we'll have to do it again, man, with some new questions. Man. And we'll keep it going, man.
Sounds great.
I'll share the link with you, and you can share the podcast. And we'll take it from there, man.
Great talking to you, man. We'll be in touch. All right.
My pleasure, man. Take care, buddy. See you.